Hello everyone, welcome to the presentation of our study wrote created by Chen Chi and Dr. Ramaningam from Faculty of Law of UKM. And the study title is Exclusionary Rule of Illegal Evidence in Criminal Cases, a comparative study of Chinese mainland and Taiwan. And here is the contents of our presentation. Number one, the topic, and to introduce the background of our paper and study. And number two, the focus of our study. Number three, what we findings for our study or from our study. And number four, the recommendation. And number one topic, Chinese Constitution, criminal law, criminal procedure law, and relevant judicial interpretations completely deny the choice of legal evidence collection. The criminal procedure law stipulates that exalting convictions by torture and collecting evidence by threats, inducements, deceptions, and other illegal methods are strictly prohibited. And however, due to the short term, there are still many places that can be improved. The scope of exclusionary of illegal evidence is changing, and the two unclearly illegal evidence exclusion procedure. Number three, defective distribution of burden of proof. And as a part of China, Taiwan is very familiar with mainland China in social environment and culture, and both belong to the mainland law system. The basic legal framework is similar, and the relevant legal theories can even be directly transplanted. Therefore, Taiwan is an important learning objective for mainland China. And the focus of this study is to sort out the exclusionary rules of illegal evidence in Chinese mainland and Taiwan area, and compare them through several aspects and analyze their difference. Finally, we provide simple evaluation and suggestion for Chinese mainland's exclusionary rule of illegal evidence. Many focus on exclusionary scope of illegal evidence exclusion procedure, and three, distribution of burden of proof. And what we have finding, and the exclusionary rule of illegal evidence in Taiwan mainly includes two rules. Number one, confession rule. Number two, evidence exclusionary rule. And both rules apply the same procedure. Both use the judge's reservation principle, which states that evidence is reviewed only at trial on application, and that excluded evidence is incapacitated. And convention rule. Number one, what is convention rule? Convention mainly refers to a conviction obtained by force, coercion, seduction, fraud, fatigue, interrogation, illegal detention, or other improper means, and conviction obtained by interrogation in violence of the statutory period as stipulated in paragraph 2 of Article 158. And under the convictions rule, the burden of proof falls on the prosecutor, as long as the defendant contends that the conviction was extracted under torture. The judge should require the prosecutor to prove the legality of the evidence. Prosecutors need to proofread transcripts and audio and video recording to make their case. If the audio or video recording is defective, the transcript cannot be used as evidence. And the second type, evidence exclusionary rule. The exclusion of evidence rule mainly applies to evidence obtained by civil servants due to violation of legal procedures, because the regulation about this part, namely Criminal Procedure Law 158, the fourth paragraph of the regulation, just the principal stipulation and the key inspects the subjective intention that violates accused person, objective circumstance, and the illegal consequence that causes it. And as for the burden of proof under this rule, Taiwan law has not clearly stipulated, but in theoretical research and practice, the burden of proof is usually allocated according to the conventional rule. And compare the Chinese mainland and Taiwan exclusionary rules. And the similarities include 4 parts. And number 1, the categories of exclusion of evidence are basically the same, including verbal evidence and non-verbal evidence. Number 2, illegal conviction is directly excluded, and non-verbal evidence such as physical evidence and documentary evidence is at the discretion of the judge. Number 3, both can examine illegal evidence between trials. And number 4, the burden of proof is on the prosecutor. But there is also some difference between them. And number 1, in the legislative model of exclusion of evidence, material evidence and documentary evidence in mainland China can be supplemented, and illegal material evidence and documentary evidence that cannot be collected can only be excluded, while Taiwan region directly considers weighing factors to determine whether to exclude. Number 2, the exclusions of illegal evidence in mainland China exists at any stage from investigation to trial in Taiwan, according to Article 273, subtracts 1 of the Criminal Procedure Law. The pretrial exclusion of illegal evidence focuses on the preparatory stage of the trial. And number 3, under normal circumstances, the proof of illegal evidence on both sides of the Taiwan Strait is borne by the procuratorial organs, but when the accused person and his lawyer apply for the initiation of the illegal exclusion procedure, the mainland stipulates that the applicant should provide relevant clues or materials to support his claim. And the recommendations for China, after comparison, we find the deficiencies in China's exclusionary rules of illegal evidence. In view of these deficiencies, we put forward the following suggestions. Number 1, verbal evidence obtained illegally should be absolutely excluded. And number 2, in principle, physical evidence obtained illegal should be excluded, but exceptions should be established to take into account the extent of the illegal act and its impact of the facts. And why these two kinds of evidence why we choose these two, and because for verbal evidence, it's totally obtained by from the accused person, and so if the obtained measure is illegally, then it is totally cannot be uh, uh, to be believed by the prosecutor or the judgment, because it is some kind of what should I say, human rights. Yes, and for the physical evidence, it is objective exists in the world. So whatever it is by obtained by illegally or legally measured, the physical evidence is existing. So it can show us the facts quite objectively. So so if it is necessary and we have sufficient evidence to occur occurs to show the physical evidence is okay or is good for the facts name, it must not be excluded. And that's all our study. Thank you.